There is a congressional settlement mechanism written into Section 415 of Public Law 141. It appears in no budget line you have ever seen. And from 1997 to 2017, it paid out $17 million in taxpayer money to cover misconduct by members of Congress. No senator's name was ever attached to a single dollar of it. For 20 years, that was by design. Here is what it actually is. In 1995, Congress passed something called the Congressional Accountability Act, Public Law 141. On the surface, it was a good government bill. It applied federal workplace protections to congressional employees for the first time. That part was real. What most people missed was what the law buried in Section 415. That section created a special dispute resolution process for anyone who worked in the Capitol and suffered discrimination or harassment at the hands of a member of Congress. That process included mandatory counseling, mandatory mediation, and a settlement mechanism paid directly out of the United States Treasury. Not from a member's personal funds, not from their campaign account. From yours. No one voted to create a secret settlement fund. That would have been a different bill, and it never would have passed. What Congress voted on was workplace protections. What they quietly attached to those protections was a system that guaranteed the institution would never have to name itself publicly in a lawsuit. The Office of Compliance was established to administer the process. It reported, technically, to a board of congressional appointees. The settlements it oversaw were confidential by statute. Section 415 said so directly. Every victim who moved through the process had to sign a non-disclosure agreement before mediation could even begin. Not after, before. That agreement held if the case settled. It held if the member retired. It held if the member later ran for a different office. The law that protected workers also, quietly, protected the people those workers were protected from. That is the structure. It was voted on, but not that part. The Office of Compliance was not an independent watchdog. It was administered by a 5-member board, each appointed by congressional leadership, the Speaker, the majority and minority leaders of both chambers. There was no external nomination, no meaningful outside oversight. The people running the system that shielded members of Congress from public exposure were chosen by the members of Congress who ran the institution. The records of that oversight, the number of claims filed, the identities of the accused, the amounts paid per case, were not public record. Annual reports disclosed only aggregate figures. A total, no names, no offices, no context. Remember, no one voted for this. The secrecy was structural. And here is what that structure did to actual people. A congressional staffer files a complaint against the member she works for. She has been harassed, maybe worse. The Office of Compliance notifies her that before any formal complaint can proceed, she must enter a 30-day counseling period. She cannot contact a private attorney and file in federal court. Congress had exempted itself from that standard. At the end of 30 days, if she wants to move forward, she enters a mandatory 30-day mediation period. 60 days minimum before anything formal happens. During this entire time, she cannot speak publicly about it. If she reaches a settlement, if the Treasury writes a check, she signs an agreement that seals the record permanently. The member's office continues. The member's reputation continues. The member may run for higher office. She has been paid and she has been silenced, and the fund that paid her is a line in a ledger that no one ever asked to see. This happened 268 times between 1997 and 2017. 268 settlements. $17.2 million, 0 public names. And here is the part that should actually worry you: it is completely legal. Every element of this system was statutory. Congress wrote it. Congress funded it. Congress protected it. The Congressional Accountability Reform Act of 2018, passed only after reporters published the $17 million figure, changed some procedures. It made members personally liable for settlements, in theory. But it did not open the historical record. 20 years of sealed files remained sealed. The name stayed gone. The Office of Compliance was renamed the Office of Congressional Workplace Rights, which sounds more transparent. It is still not subject to the Freedom of Information Act. The new name changed nothing about the structure. The structure is the point. What this tells you is not about harassment. That is the surface. What this tells you is that when Congress writes a law to protect people, the mechanism it builds can simultaneously protect itself from those people ever knowing what happened. This is not unique to one fund. Intelligence committees see what you cannot. The classification system classifies its own rules. Federal advisory panels convene private groups to shape policy with no public disclosure of who sat in the room. The pattern is always the same: a narrow statutory tool, a procedural structure. A confidentiality provision no court will touch because Congress wrote the exemption into the same bill that created the right. You are told about the right. You are never told about the exemption. The question is how many other mechanisms are running the same way right now, inside bills with good names, inside laws that promised protection, shielding institutions from the very people those laws claim to serve. You know about one fund. The act that created it is 45 pages long. What is in the other 44?